Why is it that the poorest defendants are the most likely to end up being behind bars, while the wealthiest often walk free, sometimes without ever stepping foot in a courtroom? This isn't just an unfortunate coincidence, it's a deeply embedded pattern within our criminal justice systems, where money doesn't just talk, it decides outcomes. From pre-trial detention and unaffordable bail to overworked public defenders and quietly settled corporate crimes, the rules may be the same on paper, but they're not applied equally in practice. In this video, we're unpacking the mechanics of legal inequality, how wealth protects, how poverty punishes, and why the idea of equal justice under law is far more myth than reality. We'll explore the systems that perpetuate these disparities, the real-world consequences for individuals and communities, and the structured reforms that could start to shift the balance. Stay with us because understanding this divide is the first step to dismantling it. When someone is charged with a crime, the very first advantage they have, or lack, comes down to their legal team. Wealthier defendants typically instruct private attorneys with dedicated budgets. These firms can commission forensic accountants to analyse financial records, hire psychiatric experts to assess mental health considerations, and employ investigators to interview witnesses before charges are even finalised. Their case files are reviewed in detail over weeks or months, and their lawyers have the freedom to craft complex defence strategies. By contrast, defendants relying on legal aid enter the system with a public defender who may manage hundreds of cases at once. Underfunded officers mean limited access to expert witnesses, little time for thorough review of evidence, and often no opportunity to build the kind of counter-narrative that can sway a judge or jury. In some courts, it's not uncommon for a public defender to meet their client only minutes before a hearing, hardly the foundation for an effective defence. Private counsel can also draw on professional relationships with prosecutors and judges. These connections can open doors to diversion programs, reduce charges, or non-custodial sentences. Public defenders operating under strict guidelines and without those networks have far fewer options to negotiate alternate outcomes. Research from the Sentencing Project shows that jurisdictions which invest properly in defence see lower incarceration rates and shorter sentences without any negative impact on public safety. It's not a question of changing people's opinions about crime or punishment, it's a question on ensuring that the resources available to one defendant are not determined by their ability to pay. When someone is arrested and charged with a crime, what often determines whether they go home or sit in a jail cell isn't the severity of the charge, their criminal history, or whether they pose a threat to the community, it's money. Across the United States, more than 60% of felony defendants are assigned monetary bail as a condition of pre-trial release. This means that they must pay a set amount, sometimes hundreds, sometimes thousands of dollars, to be released while awaiting trial. But for the majority, even a relatively small amount is unaffordable. They simply don't have it. As a result, they remain detained, sometimes for weeks, sometimes for months, before their case is even heard in court. Let's be clear, these individuals have not been convicted of anything. They are legally presumed innocent, and yet because they lack the financial means to bail, they are treated as they are already guilty. Being held in pre-trial detention has profound consequences. Jails across the country are overcrowded, under-resourced, and often dangerous. Detainees frequently experience deteriorating physical and mental health, with limited access to medical treatment, exercise, or even basic hygiene, but the consequences reach far beyond their cell. When someone is jailed pre-trial, their life on the outside begins to fall apart. They may lose their job, they fall behind on rent or mortgage payments, they're cut off from children and family, some are evicted, others return home to find they've lost custody of all their kids, all because they couldn't afford bail. Financial, emotional, and psychological drives many to make decisions they otherwise wouldn't, and that brings us to one of the most corrosive effects of the cash bail system: coerced guilty pleas. Faced with indefinite detention and an uncertain trial date, many pre-trial detainees plead guilty, not because they committed the crime, but because it's the fastest route to freedom. A plea deal might offer immediate release in exchange for a guilty plea and a time-served sentence. For someone stuck in jail for months awaiting trial, the temptation to accept that deal, even if they're innocent, is overwhelming. This is not speculation. Research consistently shows that defendants detained pre-trial are significantly more likely to plead guilty than those who are released. They also tend to receive harsher sentences. One study found that pre-trial detention increases the likelihood of a conviction by 13% and the length of the sentence by more than 30%. Not because the evidence is stronger, but because poor left them without options. This is how the cash bail system functions, as a mechanism of social control and economic discrimination. It punishes poverty, not crime. It creates a system in which freedom is conditional on wealth, and where pleading guilty becomes a survival strategy for those who can't pay their way out. And the effects don't stop after release. People who lose their jobs while in jail face steep barriers to re-employment. Many are evicted while they're detained, leaving them homeless upon release. Some find themselves in deeper poverty than when they entered the system, relying on emergency shelters or public assistance just to survive. It's a downward spiral, one triggered not by a conviction, but by an inability to post bail. This isn't just unfair, it's deeply inefficient and socially harmful. Jurisdictions that have reformed or limited cash bail by using risk assessments or supervised release instead have not seen increases in crime. In fact, they have often saved millions in jail costs and court resources. So the question isn't whether we can afford to change the cash bail system. The question is whether we can afford not to. If we believe in the presumption of innocence, if we believe in equal treatment under the law, and if we believe that freedom should not be tied to a price tag, then we have to acknowledge the truth. The cash bail system does not serve justice, it serves inequality. Let's talk about plea bargains, arguably one of the most misunderstood yet most powerful forces in modern criminal justice. In many jurisdictions, as many as 95% of criminal cases never make it to trial. They're resolved through plea bargains. On the surface, this might seem efficient: fewer trials, reduced court backlogs, faster resolutions, but beneath the efficiency lies a far more troubling reality, especially for those defendants who are poor. For someone who's been detained pre-trial, often because they couldn't afford bail, the pressure to plead guilty is enormous. You're stuck in a cell, unable to work, possibly losing your home or your children, while your case drags on through a slow-moving court system. Then you're offered a deal: plead guilty now and go home, or sit in jail for weeks or months waiting for a trial you may or may not win. For defendants with money, there's time. There's a private legal team, there's the option to fight the charges properly. But for those who without resources, especially those who can't afford to post bail or hire a private solicitor, the plea deal starts to look like the only viable path forward, even if they're innocent. And let's be clear, this isn't hypothetical, it happens every day. People admit to crimes they didn't commit, not because they're guilty, but because they feel like they have no other choice. These guilty pleas come with long-term consequences: a criminal record, mandatory minimum sentences, loss of voting rights in some jurisdictions, barriers to employment, loss of access to public housing or educational grants. It doesn't matter how minor the offence is or how flimsy the evidence is. Once that plea is entered, the damage is done. Plea bargaining was never meant to replace trials altogether. It was intended as a tool of last resort. Instead, it has become the backbone of criminal prosecution, a system where speed and case volume are prioritised over fairness and accuracy. And once again, it's the poor who pay the price. Wealthier defendants can afford to delay, investigate, and negotiate. They often receive better terms or avoid criminal records entirely through diversion programs, but poorer individuals are pushed into deals early without leverage and without the benefit of a strong defence. It's worth remembering that when a plea is entered, there's often no full investigation of the facts, no witnesses called, no cross-examination, no public record of evidence. The court simply shows conviction and the system moves on. What we're left with is not a process based on guilt or innocence, but on expedience. And that expedience disproportionately targets the most vulnerable, the poor, the marginalised, and those without access to proper legal support. If we want a justice system that genuinely protects rights and upholds fairness, we need to rethink how plea bargaining is used. That means ensuring defendants have meaningful access to legal advice, time to prepare a defence, and release conditions that don't coerce guilty pleas. Justice should not depend on who can afford to wait it out, and no one should feel compelled to admit guilt just to go home. Even after conviction, the gap between rich and poor doesn't close, it unfortunately widens. While sentencing guidelines are intended to promote consistency, the reality is that judges retain significant discretion. They can impose fines, order probation or community service, or hand down custodial sentences. And while two defendants may face identical charges, their outcomes can differ dramatically, not based on what they did, but what they can afford. Data consistently shows that defendants represented by private counsel receive sentences on average around 20% shorter than those with public defenders, even when controlling for the type of offence and criminal history. This isn't because the charges are lighter or the circumstances more favourable. It's because private lawyers have the time, resources and relationships to argue more effectively for leniency. But sentencing disparities don't end with prison terms. Courts frequently impose fines, court fees and restitution orders that far exceed what poorer defendants can reasonably pay. And when someone can't pay, it isn't treated as a civil debt, it becomes a criminal matter. Non-payment can result in the revocation of probation, extended supervision or even additional jail time under contempt proceedings. It creates a vicious cycle. A person is punished for being poor and then punished again for not having to pay. Elite defendants, on the other hand, often avoid this spiral altogether. They are more likely to receive reduced fines through negotiation, and they are frequently deemed eligible for diversion programs such as drug courts, mental health courts, or restorative justice schemes. These alternatives to incarceration are designed to address the root causes of offending, and they work. but access to them is often uneven. Judges may base eligibility on perceived stability, stable housing, employment, family support, but in practice these are proxies for class. Those who can present themselves as low risk, compliant and resource backed are channelled away from prison. Those who can't, often because they're poor, are not. We see the same dynamic with home confinement. Wealthier defendants can serve their sentence in their homes, sometimes with electric monitoring rather than in prison. They continue working, caring for their children and participating in community life, whereas poorer defendants, even when facing the same sentence length, are far less likely to be offered that option. At its core, this reflects a system where discretion operates without adequate safeguards. Judges may not intend to discriminate, but without clear socio-economic criteria in sentencing decisions, wealth itself becomes a mitigating factor, something that softens punishment. Poverty, by contrast, functions as an aggravating factor, making custodial sentences more likely, fines more burdensome, and alternatives less accessible. So while the law may claim to treat everyone equally, the outcomes reveal a starkly different picture. If we're serious about fairness in sentencing, we need to limit the role wealth plays in determining outcomes. That means enforcing caps on fines relative to income, standardising eligibility for diversion programmes, and collecting disaggregated data to track disparities in sentencing decisions. Because justice shouldn't bend to privilege and poverty shouldn't be punished more harshly than the crime itself. Let's now look at one of the most corrosive features of modern justice systems, selective enforcement. How certain types of crimes are pursued relentlessly while others, often more damaging on a societal scale, are quietly ignored. Across many legal systems, low-income communities experience the full force of the law. Street-level offences like petty theft, drug possession or fare evasion are policed aggressively, prosecuted quickly and punished harshly. These are the types of crimes that generate arrests, fill courtrooms and result in short but frequent custodial sentences. Now compare that to white-collar crime. Large-scale financial fraud, tax evasion, market manipulation, environmental violations, money laundering. These are crimes that can devastate communities, defraud governments of billions, and destabilise entire sectors of the economy. Yet they are far less likely to lead to prosecution, let alone prison time. But why is this? One reason is that investigating complex financial crime requires resources, time, and expertise that many enforcement agencies simply don't have. Forensic accounting, data analysis, international cooperation. These tools are expensive and public regulators are often underfunded. Prosecuting a burglary may take days. Prosecuting corporate fraud can take years. But it's not just about capacity, it's also about political will. Under certain administrators, particularly those with strong ties to corporate interests, prosecutions for white-collar crime have been plummeted, even as corporate wrongdoing has continued at pace. Regulatory bodies face mounting political pressures to go easy on businesses, and when enforcement does happen, it's often in the form of deferred prosecution agreements, settlements that avoid criminal convictions in exchange for fines. We've seen this with major banks implicit in money laundering scandals, with pharmaceutical companies involved in illegal marketing, with tech firms facing data privacy violations. These institutions pay hefty sums, but crucially, no one goes to jail. The corporate entity pays the price, not the executives who made the decisions. Meanwhile, a teenager caught with a small amount of cannabis might spend months in a remand centre awaiting trial. A homeless man stealing food could face immediate arrest and a criminal record that limits employment for life. These outcomes don't just affect those directly involved, they shape public perception, they erode trust. Because when people see low-level offenders being locked up or high-level offenders cut deals behind closed doors, it begins to look a lot less equal to justice, and more like a two-tiered system, one where the law enforced swiftly and brutally for the poor, but flexibly and quietly for the wealthy. That perception has real consequences. It fuels distrust, undermines the legitimacy of institutions, and weakens social cohesion. People stop believing that the law is neutral, and when faith in the criminal justice system collapses, the system itself starts to break down. So what can be done? We need to rebalance enforcement priorities. That means properly funding regulatory agencies, expanding white-collar crime units, providing prosecutors with the tools and training to handle complex cases, and crucially, ensuring that individual accountability is pursued in corporate crime. Fines are not enough. If working-class people go to jail for small-scale offences, then corporate executives must face real consequences for large-scale wrongdoing. Justice must not only be done, it must be seen as done. Because society that punishes the poor and shields the powerful cannot claim credibility to uphold the rule of law. Let's now turn to a critical aspect of the criminal justice system, how race and poverty intersect, amplifying the disparities we've already discussed. We can't talk about inequality in the justice system without acknowledging the racial dynamics that compound the burden on already vulnerable communities. Black and minority ethnic communities are disproportionately represented among the poor, and as a result they bear the brunt of systemic injustice in ways that are both direct and insidious. Take for example cash bail. We've already seen how poverty itself can be a mechanism of detention, where individuals who can't afford bail remain incarcerated before trial, often for extended periods. But studies show that black defendants are more likely to be assigned bail in the first place, and the bail amounts they face are frequently higher than for white defendants charged with similar offences. This means that black individuals are more likely to stay in jail before trial simply because they lack the financial means to secure their release. This isn't just about bail. Racial disparities stretch across the criminal justice system. In many jurisdictions, black defendants are more likely to be charged with crime at all, and when they are, they face harsher sentences than white defendants for comparable offences. While socioeconomic status is the immediate driver of many of these disparities, racialised policing practices only serve to deepen the problem. Minor infractions, like traffic stops or low-level drug arrests, are often enforced more aggressively in black and minority ethnic communities. These encounters, which might seem trivial in isolation, act as a funnel into the criminal justice system, disproportionately drawing people of colour into a cycle of arrests, incarceration and legal penalties. The over-policing of these communities doesn't just result in more arrests, it reinforces a self-fulfilling prophecy, where poor and minority communities are treated as inherently criminal and subject to constant surveillance. At the core of this issue is discretion. Police officers have the power to make decisions about who they stop, who they search, and who they arrest, and racial bias, whether implicit or explicit, often shapes these decisions. It's not simply about isolated incidences of racism, it's about a pattern of radicalised policing that disproportionately impacts black and minority ethnic individuals who are more likely to face harsh criminal sentences. The result is a radicalised pipeline into criminal justice system, where economic hardship and racial identity overlap that produce disproportionately negative outcomes for people of colour. This creates a cycle where poverty isn't just a cause of incarceration, it's exacerbated by it, increasing the likelihood of future contact with the justice system. The statistics bear this out. Black and Latino individuals are incarcerated at much higher rates than their white counterparts, and black defendants are more likely to be sentenced to prison for the same crimes as white defendants. The effects are devastating, not only for those individuals but for their families and communities. As people of colour are more frequently incarcerated, entire communities suffer from the economic, social and psychological toll of mass incarceration. What's critical to understand here is that the racial inequalities we see in the criminal justice system aren't just the result of bad actors or isolated cases of discrimination. They are part of a broader structural issue. Socioeconomic disadvantage is magnified by racial bias in policing, sentencing and incarceration. These intertwined forces create a feedback loop that perpetuates both poverty and racial inequality, making it hard for affected communities to escape the grip of the criminal justice system. To address this, we need to do more than just fix the way we talk about race. We need to reform the systems that sustain these disparities. That means revisiting bail practices, ending discriminatory enforcement, investing in community-based alternatives to incarceration, and addressing the racial biases that infiltrate every step of the process, from policing to sentencing. If we truly want to achieve a fair and just system, we need to recognise that racial and socio-economic inequalities are not separate issues. They are deeply interconnected, and until we address both, we cannot claim to have justice for all. So what does meaningful change really look like? Because it's not enough to simply point out the flaws, we need to fix them, and that means systemic reform, not superficial adjustments. First, we need to abolish or fundamentally reform cash bail right now. Money, not risk, decides who walks free. That has to change. Replacing cash bail with evidence-based risk assessments ensures that decisions are made based on safety, not someone's bank balance. Second, it's time to invest properly in public defence. That means manageable caseloads, access to expert witnesses, and the time and resources needed to mount a proper defence. When we do this, wrongful convictions go down, and justice becomes less about wealth and more about truth. Third, we must standardise sentencing. Too much discretion leads to too much disparity. Sentencing guidelines should be consistent, transparent, and reflect a person's actual capacity to pay. No one should be sent to prison simply because they're poor. Fourth, let's talk about white-collar crime. It's time to stop treating financial misconduct with kid gloves. Dedicated investigators and prosecutors should be going after complex fraud with the same energy used to pursue low-level offences. No more hiding behind corporate settlements while lives are destroyed by petty charges. Fifth, we need to expand access to diversionary programmes like mental health courts, substance abuse treatment, and community service. These alternatives to incarceration should be available to everyone, regardless of their income, and they must be free at a point to use. And sixth, we have to mitigate the long-term consequences of conviction. That means banning discriminatory practices in employment and housing, restoring access to public benefits, and giving people their right to vote back. Because once someone has served their time, they deserve the chance to be rebuilt without carrying the weight of permanent punishment. These aren't radical ideas, they're fair ones. When implemented together, these reforms bring us closer to a justice system that actually lives up to its name, one where neither wealth nor poverty is destiny, one where outcomes are based on facts and fairness, not on privilege or prejudice. Now let's bring it to a full circle. The divide between rich and poor in the justice system isn't accidental. It's the result of deliberate policy choices, funding decisions, and decades of political inertia. Poor defendants face an uphill battle at every stage, from the moment they're arrested to the day they're sentenced, and often even after release, they continue to carry the weight of their punishment in every corner of their lives. Meanwhile, wealth shields others, from jail time, from scrutiny, even from being held accountable in the first place. That doesn't just violate the principle of equality before the law, it erodes public trust in the system entirely. But this is irreversible. A more equitable system is possible, but only if we confront these truths head on, only if we commit to changing the rules, not just the rhetoric. If this video gave you something to think about, help amplify the conversation. Like, share and subscribe for more deep dives into the issues that matter, and drop a comment below. What reform do you think is most urgent? I want to hear your thoughts. Until next time, stay informed, stay critical, and remember, justice doesn't trickle down, it's built from the ground up. Thank you for watching.